Today we're going to discuss the number one reason why domestic asset protection trusts, or foreign asset protection trusts for that matter, fail. So let's get into it. All right, the number one reason why domestic and foreign asset protection trusts fail is, all right, we'll get into it here in a second, but just as a general housekeeping rule, I want to focus on domestic asset protection trusts because that's what I really know and have done with clients, is provide these solutions for domestic asset protection trusts. And that means that the trust itself is settled or established here in the U.S. according to a jurisdiction within the U.S. Foreign or offshore asset protection trusts are set up in jurisdictions other than a state within the United States. But they fail for the same reasons, all right? And the number one reason that these fail is because of what's called a fraudulent transfer or a violation of the fraudulent conveyance doctrine. And so what this says is that you cannot intentionally defraud a creditor who has a claim against you or who might have a claim against you, right? And so I said that you cannot intend to do this. And so it is an intention to defraud the creditor, and this intention has to be proven by the creditor. So that's one aspect of this. I'm going to talk about something called a statute of limitations here in a second. But this intention must be proven. It's important to keep in mind that different states have different laws around intent, and then also what is going to prove that intent. So it's on the personal creditor who's bringing the claim that you're defrauding them. It's on them to be able to provide enough evidence to prove that you have the intent. I'm not going to go into a lot of detail regarding that because frankly it'd probably bore you, but just know that there is this aspect of intent that has to be proven to in fact determine that you have made a fraudulent conveyance. The other thing to keep in mind is that a fraudulent conveyance is not just to a trust. It could be to an individual, it could be to an LLC. It's going to possibly occur anytime that you move assets from yourself to someone else, whether it is in a actual sale, some type of transaction, or it's a gift or an assignment of the asset. So that's something to keep in mind. Now, there's a statute of limitations that's associated with this fraudulent conveyance. So not only does the creditor have to challenge any conveyance, but they have a certain time. They have to prove the intent, but they have a certain amount of time to be able to do it. So that's what varies greatly among states. So in 2025, as I'm making this video, I believe there's 20 states that have domestic asset protection laws that allow you to set these trusts up in these jurisdictions. Really 5 or so are worth talking about, but only 2 are really worth using generally to establish your trust. That would be Nevada and South Dakota. I've always done in South Dakota. South Dakota has better trust laws, although they are nearly identical, but overall South Dakota has better trust laws. Now, this statute of limitations in South Dakota and Nevada, it's 2 years. Well, it's really a two-pronged test, but it's 2 years. So someone has the ability to challenge a transfer that you made within 2 years of that transfer. So, and then that's when they would prove that you had the intent. If they had notice that you actually had made the transfer, whether it's a potential creditor or a pre-existing creditor, they have 6 months to bring the challenge. So if you thought it was a better strategy to put this person on notice that you'd made this transfer, then they would only have 6 months. Ohio, which has a domestic asset protection trust law or statute, has the shortest statute of limitations at 18 months or in 6 months for that two-pronged test. Then you also hear about states like Wyoming, Alaska, Delaware, and they do historically have had really strong trust laws, particularly with domestic asset protection trusts, but they aren't 2 years. I believe they're 4 years, maybe even 5 years. I can't remember. I'd have to look it up again, but they aren't 2 years like Nevada, South Dakota, not 18 months like Ohio. So those are the 2 things to take away. There are other ways that these trusts could fail, but we've never seen those issues actually litigated. And really, it's a constitutional law question. and I won't go into detail about that. I think I have some other videos about that, or I'll come out with another video about that. But where we have seen these challenged over the last 20, 30, 40 years is this issue of fraudulent conveyance. And so before I wrap up here, I will say, I think one of the more recent stories that I read, and it had to do with an offshore trust in a settler person setting up a trust, transferring assets to that domestic or that foreign asset protection trust. A judge in, I believe, Illinois got involved to determine whether or not there had been a fraudulent conveyance, that the intent was there and that it happened within the statute of limitations. And the judge said, yeah, in fact, this is a fraudulent conveyance. So they told the settler, person setting up the trust, that they had to unwind the transfer. They had to bring it back. They had to remove it from the trust. And there are the mechanisms there to be able to accomplish that. But this particular settler refused to do it. So the judge held him in contempt of court and threw the person in jail until they decided to unwind or unravel the actual transfer. So that's one of the consequences that we've seen. It's not necessarily a criminal event that occurs, but it is civil, and therefore a judge could put you in jail for contempt of court if you do not unwind the transfer. So have to have intent, has to happen within the statute of limitations. Rules, laws regarding those two things differ in different jurisdictions. But again, South Dakota has the strongest laws, particularly because it has great privacy laws coupled with those asset protection statutes.